Right. Good afternoon. I hope you're all doing well. I'm Ashley Ebersole, and I'm General Counsel of 0x. So thanks so much for being here with me today, and thanks to ECC and the organizers for getting us all together here in Paris. I'll be honest that there are a lot of topics here that go beyond my technical grasp, but something I do know is law and regulation, so that's what I'm talking about today. I've been working on these issues since I joined the US SEC in 2015 and became part of the working groups there that were looking at crypto regulatory issues. I continued that work when I left the SEC for a law firm in 2019, and about a year ago, I joined 0x to head its legal team. And I'm a lawyer, so I have a disclaimer, or two actually, which is that none of what I'm saying is legal advice, and these are my own views, not those of my company, or certainly of the SEC, at which I no longer work. So let's get started. Let's start with the United States. I love my home country. I love my former employer, the SEC. They've made some really important moves in this space. I think that to fulfill their true mission, they need to think a little bit more flexibly, especially when looking at things like disclosure requirements, things like custody requirements, things like KYC, and how those might look differently in different technologies. And there should be regulations and controls that account for those. And in the United States, there just are not at present. So looking at the market regulatory agencies like the SEC and the CFTC, you've really got a pretty stark contrast between them. The SEC's jurisdiction is fairly narrow in that it's only over securities, but they've asserted it pretty broadly in this space. And a lot of things have gotten pulled into the definition of what is a security. The Ripple order earlier this month has walked that back a little bit. The court essentially told the SEC that it does not necessarily agree with that expansive approach. That's so recent, it's tough to tell precisely what the ramification or reverberations will be throughout other courts, throughout other cases in the court that issued the Ripple ruling, the Federal District Court in New York. But it was certainly a very welcome development. What comes next in that regard is still TBD, obviously. Then there's the CFTC, which is the commodity regulator, but it's really the commodity derivatives regulator. So Bitcoin has been classified as a commodity. There's no regulator of the spot market in Bitcoin. Bitcoin derivatives are regulated by the CFTC. So it's a little bit of a strange situation and leaves a lot of people to sort of say, well, does it really matter in that case? If you've got two regulators, there are these boundary lines and they're not always clear. Does it matter where you end up relative to those boundary lines? And my answer is yes, it matters a lot. The two regulators have shown very different approaches and very different, I guess, perspectives and enthusiasm for this technology. You've got the SEC, where there's been a pretty well-known hostility of the current chair of the SEC towards crypto. As long as he remains at the leadership, I don't really expect progress there from a regulatory perspective. They have essentially put a stop to further guidance, further actual regulation of this space, like prescriptive things of this is what you need to do, beyond saying you need to fit into the traditional rules that exist for broker-dealers, for exchanges, for custody, and that sort of thing. CFTC, the commodity derivatives regulator, has been a little more flexible, a little more accommodating of the fact that there may be differences, and they will account for those in advance, as opposed to only doing what the SEC has done, which is accounting for them after the fact by filing enforcement actions. But like I said, the CFTC's jurisdiction is much narrower. So both agencies badly want to be anointed the spot regulator of the crypto space, of the Bitcoin market in particular, and Ethereum and other things like them, but neither can necessarily claim that based on what their current jurisdiction is, at least not in any definitive way. So Congress could pass legislation that says it's the SEC or it's the CFTC, but that takes time and that takes a lot of effort to get something through Congress. Hasn't happened yet. Perhaps it will. That would be a game changer if it did. Across the ocean, where we are now, and the picture is dramatically different. There's a veritable welcome wagon rolled out for crypto entities and those who fund them. MICA's, that's the Markets and Crypto Asset Regulation that's currently being implemented across the EU and its member states, and nothing like that exists in the United States. It's sort of strange to say. There's no crypto asset regulation law written in the United States. There's some guidance from the SEC, some guidance from the CFTC, but if you look in statutes, that's the United States Code, you'd be hard-pressed to find much that is crypto-specific. The EU Parliament has, done something dramatically different and has new written law out that's pretty prescriptive. So in the US, entities say, even those that really want to be compliant would grab a regulation or grab a registration in a second if it existed, rather than trying to become a broker-dealer and just not fitting into that regulatory sphere narrowly because things I mentioned, there are custody requirements, and they look at the regs and they say, well, I can't comply with that. Like, what are they talking about? Cash accounts and stuff. Like my clients don't put cash with me. I don't have the ability to take cash, that kind of thing. Like, just a lot of disconnects that in the first instance lead a lot of crypto entities to look elsewhere for the path they need to follow. Europe's now created a path. There is a regulatory registration for crypto asset service providers, and that becomes a very viable path that is well-defined, is built out as to how you achieve compliance, is built out as to how you form an entity and the steps you have to go through, and that may well prove quite attractive to entities in this space going forward. Like I said, it's in the process of being rolled out now, as many in this room know, but as you'll see in a minute, already the money is showing us, or moves of money in terms of funding entities is showing us that people are taking notice. I guess the last note, especially important to entities like 0x, is that in the DeFi space, MICA has, in its first iteration, said DeFi is a bit of a different animal from centralized entities, which we know how to approach. Those have been regulated for quite some time in various forms. If you're a centralized entity in the financial space, whether you're dealing in crypto or something else, you should expect that there are regulations, and here they are. We've written them now for how you achieve compliance and what you need to register as. In the DeFi space, they didn't throw up their hands, but they sort of admitted their limitations and said, we don't quite know exactly what regulation of DeFi needs to look like yet. We need to study it a bit. So there's a study period currently ongoing for 2 years. And at the end of that, they will assess and say, all right, we believe we've reached some conclusions, and this is what regulation should look like. But again, for now, that's still to be determined. I'd be remiss if I didn't mention that there is also pending a new anti-money laundering law that will apply to crypto entities in the EU space. Thank you. In the EU space. That is still a consultation paper. What the final law will look like is, still to be determined. But, I'm also not an EU lawyer, so plenty of folks in your relevant jurisdictions with whom you can speak once things are more certain in that regard. Like I said, the ramifications of the relative moves in the United States and in Europe have started to become a little bit more clear. United States, you have a regulator, principal regulator, the SEC, who's focused on filing lawsuits, whereas in Europe now, you have a regulator who has been focused on writing laws and implementing new laws. So you don't have anything like opinion polls, obviously, but you can look at the behavior of people and entities in response to the laws. And like I said, still early, still tough to tell exactly what's driving things at this point, but it seems clear that there's been a reaction against the lack of a clear approach in the United States and the SEC's approach, which again has been lawsuits and hostile pronouncements publicly. This visual shows where VC investment in the space is going geographically. Economists are familiar with the term voting with your feet, where people, capital, entities move to jurisdictions that have more palatable regulatory environments, legal environments. VCs have been voting with their funding. You can see here, as you move down in time, you're going from the top of the slide to the bottom. The top is Q1 22, the bottom is Q1 of 23. You see the funding volume in the US has fallen to less than half of where it was over the course of a year. Europe is the gray color. Europe has taken all of the loss of the US as well as the relative loss of some of the other geographies on here. So again, whether it's MICA, the expectation of MICA, the promise of clarity, tough to tell, but it's difficult to argue there has not been some recognizable effect. And then you see in this slide that the jobs follow the money. We see the relative movement of Web3 jobs over the last year, and currently Europe has the dominant share of those jobs, followed by Asia. Overall employment numbers, definitely down since the end of 22, but there's nonetheless been a market shift in where these jobs are located. And the decrease in jobs has been less severe in other locales versus the decrease in North America. So there's been a relative market share loss in the United States that is more severe than other places. Asia's now replaced it in second place for these jobs after Europe, which is in the lead. Having looked at the data, I think the message is clear that the numbers underscore the importance of location for both funding and growing crypto businesses. Founders should have thoughtful responses justifying a choice of location, and stats show that people are choosing based on likely legal factors, and that's a defensible choice. Clear regulation matters. People have to know the rules that apply to them if they want to play by them, and the US is not making that easy. So thank you so much for listening. I've got probably time for one question, maybe two, if anyone has them. One in front.
What do you think so I thought thank you. I thought your comparison between the US and Europe with data was really cool and interesting. But what do you see as a path forward for the US, given your experience with the SEC and participation in the industry? What does that look like in an ideal world, not maybe practical?
I think an approach like what Europe has taken in terms of an iterative consultation process would make a lot of sense. The CFTC has started something similar recently with an industry consultation group, effectively, of people who it has said, we're here to say we don't 100% know what's right for this space. We don't 100% grasp all of the technology and its implications, so we're going to bring in the people from your industry and talk to them about it. I think that's really constructive. I would leave it to the regulators to decide at that point, where can we go going forward. I think you need some written law rather than trying to parse the holdings of enforcement actions and the outcomes of court judgments. Thanks so much. Where can we go going forward? I think you need some written law rather than trying to